Welcome back, everyone. We'll now go on to the next standing committee of the Bellingham City Council. It's the Justice Committee. Councilmember April Barker is the chair.
Thank you, Councilmember President. I'm joined today with Councilmember Bornman and Vargas. We have one item for committee, and that is a presentation by the Vera Institute of the Justice on incarceration reduction strategies. And I'll just say for the new faces in the room here, this is a Justice Committee that was just put together this year. It's specific to looking at systems and ways to improve those systems. Lately, we've been doing a lot of education of just those systems in general. So if you'd like to access those meetings, you can go to our council webpage, click on hot topics, special items, top issues, and go to the justice section. And if you're interested in housing, there's one for housing there too. So I would like to acknowledge some of the people that are in the room today. We have Jill Bernstein, who is a co-chair, well, actually, she's with Law Advocates and a co-chair of the Incarceration Prevention and Reduction Task Force with Jack Hovenier. Is that right? And then we have Chief Hewitt from the Fire Department. We have Darlene Peterson, which is our court administrator and has been really awesome at bringing forward information and helping us understand, one, what a great job we're doing and how we can do better. And with that, Liz, I'll give it to you, and then maybe you could introduce your group. Okay, Liz Swovel with the Vera Institute.
There's a red button. Make sure it's on.
Yes. Thank you. First of all, thank you so much for inviting us here today and giving us this opportunity to share this information with you. We just did a 4-hour presentation to the task force, so we're hoping that we can condense everything we shared with them into the next 30 minutes. So we're going to speak very, very quickly. I'm Liz Swovola, and I'm a senior program associate at the Vera Institute of Justice, which we'll tell you more about in just a moment, but I'm going to let my team introduce themselves.
Hi everyone, my name is Vaden Anthony North. I'm a program associate with Vera's Substance Use and Mental Health program.
Hi, I'm Steve Roberts, and I'm a senior research associate with the Center on Sentencing and Correction at Vera.
I'm Christy Riley. I'm a program associate, and I'm also with the Center on Sentencing and Corrections.
Okay, and then just one more recognition. I'm sorry, Barry, I didn't see you up there, but we also have in the audience County Council President Barry Buchanan. Thank you.
Great, thank you. So, we wanted to start today by telling you a little bit about Vera. The Vera Institute of Justice was founded in 1961, so we've been around for a few years. We're an independent nonprofit organization. We study and analyze problems in justice systems and work with communities to come up with solutions, as we've been doing the past year here in Whatcom County. At the Center on Sentencing and Corrections, which many of us are members of, we improve outcomes for justice-involved individuals by advancing access to high-quality college education behind bars and reducing solitary confinement, and also by closing the front door to mass incarceration by reducing the overuse of jails, which is why we are here today. So we want to start by giving you some national context. As I said, Vera has been doing this work for several decades, working with local counties first to understand what's driving their local jail populations and then to come up with targeted solutions that will work specifically in their community. But we wanted to give you an idea of what's happening across the country so you know why we do this work and what we've learned in doing that work across the country. So, as you'll see on this slide, after 2 decades of declining crime rates, our country is the safest it's been since the 1970s. But at the same time, incarceration rates have continued to climb. And so what we've learned that at a certain point, in the early 90s, we really reached a point of diminishing returns, where each increase in incarceration made us no less safe. And as the number of people coming into local jails has increased, the percentage of people that are pre-trial, so that means they're awaiting resolution of their case, they are not yet convicted, and those that are convicted have actually reversed. So now about 62% of people in jails across the country are pre-trial. Although probable cause has been established to hold them in jail, they are legally presumed innocent. And so as more and more people come into the system and they stay there, And we've learned that increasing rates of cash bail have increased the time that people stay in jail. And we've seen the length of stay increase. And as you can see here on this chart, in 1983, the average length of stay was 14 days. In 2013, it was 23 days. And systems slow down, case processing slows down. But it also has, pretrial detention also has impacts for individuals and for public safety, but not in the way that you might think. What the research shows us is that when low and moderate risk individuals are held in jail for no more than 24 hours, so we can even be talking about 2 to 3 days, just staying in jail for a weekend, they are actually more likely to be arrested both before trial and up to 2 years after their cases are resolved. And so when we think about public safety, holding people in jail may not make a lot of sense. We know that it disrupts employment, it disrupts any treatment the individual might be engaging in, education, family ties. It can really set off a domino effect in that person's life.
So we're going to show you some of our findings from analysis of data. We received a lot of data, particularly from the county jail, and that's most of what we're looking at here. First, I want to introduce a few terms. We're going to be talking about admissions, and that's the number of people, all the people who are admitted to the jail during the course of, in this case, 1 year. We looked at the year 2016 from the jail's admission data. There were about 6,000.
Steve, could you bring the microphone a little closer to you? Thank you.
There are about 6,000 people admitted to the jail in 2016, so some of these numbers I will repeat a few times. We also talk about length of stay. That's the time from their arrival to their release, their booking until their release date. The longer length of stay, the more people you are likely to have in your jail. Our third term is average daily population. That's the most important. This is if you were to walk into the jail today, it's the population that you see. So on any given day, in this case, in 2016, the average daily population refers to all the people in jail on that day. In 2016, the average was 324 people. As Liz mentioned, a great percentage are pretrial, so 192 of those people were in jail pretrial waiting for the disposition of their cases. So a few key data takeaways, we'll just step through these quickly, are that people who are pretrial make up a significant portion of the average daily population. Again, that's 192 out of 325 people, or about 59%. Charges related to substance use are significant drivers of both admissions and length of stay. Financial bail lengthens the amount of time people stay in jail and also reduces their chance of getting out and being released pretrial. And to reduce admissions, we want to address the drivers of non-felony bookings. So this is particularly about the number of people coming into jail. The admissions part of it are often driven by low-level non-felony charges, especially those involving warrants, and we'll see numbers on those later. And to reduce the average daily population, you have to work with the people who are generally staying there a long time. So you want to shorten case processing times, the amount of time a case takes to resolve in the courts, and especially for the higher level felony charges. And then finally, to impact racial disparities, and I should say to reduce racial disparities in the average daily population, we should look at the disparities in admissions because that's where they're most pronounced. And here are our recommendations. These are the summary of the recommendations. We're going to step through each one of these as we go along. The first is to reduce unnecessary admissions to the jail. Second is to curtail the number of new and outstanding warrants for low-level charges. The third is to create pretrial release process that is individualized and based on data-driven risk assessment. To develop a case flow management plan to reduce time to disposition and shorten defendants' lengths of stay. And the fifth one is to develop an oversight and accountability mechanisms. So this is the first data slide that I'm going to show you, and we're going to go through some of these pretty quickly because I think we really want to focus on the recommendations. But these are the agencies, the law enforcement agencies that are responsible for bringing people into the jail. And these counts are of the average daily population, so these aren't admissions. This is if you look at the jail on a particular day. A typical day shows that 132 people there have been brought in or have been booked by the Sheriff's Department, 109 by the Bellingham Police Department, and then the rest of the municipalities, the DOC, the State Patrol, others who can contribute to the jail population. And
Excuse me, Steve.
Yes.
Pinky has a question.
Steve, can I ask a quick question about those numbers? Is that point in time when that snapshot was done, these particular numbers, about what time it was? Because obviously last year we changed a lot of things in regards to who we're incarcerating. So I'm curious about the date,
This
point
is
of
actually
time.
over the course of the whole year. So when we say snapshot, you could say a snapshot of any one particular day. We actually took a 365 snapshots and
Okay.
averaged them. So this is the average over the course of the year.
Thank you.
Go ahead.
So we're looking at admissions now. So this is the number of people coming through the jail, not so much the population. But the top charges admission-wise, we have two tables here. One is for gross misdemeanors, and the second is for misdemeanors. You see the top gross misdemeanor charge is assault in the 4th degree, and there are 393 admissions. A few other things to point out are that if you look at the 3rd and the 4th line of the top chart and the 4th line of the bottom chart, they have a /FTA. Those are people who are being brought back to jail because they failed to appear for a court appearance. So this is starting to touch on the warrants that we talked about before. A lot of people are arriving in jail because of outstanding warrants. And a lot of these people are people who wouldn't be in jail because of the underlying charge, but only because of the warrant. The probation and parole violations are also make up a number of a substantial number of admissions, 149 in 2016, and those are people who have violated the conditions of their probation, and so they are being brought into the jail too. Now, some of these people are being brought in because the actual violation is committing a new crime. About 56% of these people are being brought in solely because of a technical violation and not because of a new crime. And of that group, on any given day, they're filling 7 beds in the jail. They tend to stay for an average of about 18 days when they're brought in for a probation violation and do not have a new charge. And these are specifically local municipal probation violations. I think about 80% of them were municipal. This is not DOC probation. That's tracked separately. And these are the criminal traffic violations. You see by far the biggest number are the DUIs. And then the second one down is driving while license suspended in the 3rd degree, which is the least of the license suspended charges. And what we found are that of this group, 90% of the people being brought in have warrants for their arrests. So these are another group of people who likely would not be coming to jail were it not for the warrant. It's not the underlying charge that brought them to jail. This is a measure of the number of people who were booked over the course of the year who were referred to the jail behavioral health program. So it's a simple slice of the pie. 32% of the people booked into the jail were referred to jail behavioral health services. This isn't really an indication of diagnosis. These are simple referrals, and some of these people may have been referred more than once. Some of them may actually have been booked more than once into the jail. But it's kind of our first level indicator of the behavioral health requirements of the jailed population.
And Steve, it was clarified in committee today. These are self-referrals? These are
No,
people?
they include self-referrals,
They
but
include
they're not all
self-referrals.
self-referrals.
Okay, thank you.
And just a point of clarity that we only analyze distinct individuals to get this number. So even though an individual might have made multiple referrals, we only looked at individuals who referred. And the same thing with admissions. We only looked at distinct individuals who were admitted to develop this number. So based on the data findings, Vera identified a number of opportunities for response to these challenges. I'm going to run through these somewhat quickly and hopefully keep them focused on Bellingham-specific opportunities. Our first responsive strategy is to decriminalize select low-level municipal charges. What we heard over the course of a year was that due to the overcrowding in the jail, law enforcement was already making a lot of use of issuing citations when possible instead of relying on a custodial arrest. That's a great practice, and we think that that's great. To further the opportunities for giving law enforcement other options, we suggest looking at the municipal codes and seeing if there are specific violations that could be dealt with as a civil matter rather than a criminal matter, like a nuisance offense. Our understanding is that Bellingham has already taken some steps towards this end, but we encourage you all to continue looking and seeing if there are other opportunities. And the great thing about this is that it really does allow you to continue to hold people accountable for their behavior, but just dealing with it in a different type of way. Our next idea for you all is to expand the use of book and release. So again, this is something that Bellingham has already been using and Whatcom has already been using to some degree, and we really think that there's opportunity to expand that use. So book and release is a practice that law enforcement might use that's a step in between a citation and a full booking into the jail. So what would have to be done is you would have to identify certain types of people and events that would allow you to take them into custody for a short period of time, maybe just bring them to the police station and cite them there, and then issue a PR bond where they could then be released directly from the station. We think doing this with a special focus on some of the charges that are driving admissions to the jail would be really important. We identified specifically focusing on those charges that are driving FTA admissions, specifically theft in the third degree and criminal trespass in the second degree, though there might be other opportunities, as well as misdemeanor and gross misdemeanor charges that aren't already in warrant status that are also driving admissions to the jail, like malicious mischief in the third degree. As Bellingham pursues this opportunity, the Bellingham Police Department should explore whether they can book and release people directly from the station rather than bringing them to the jail to do this. And then as you explore this, you might find that they're already doing some of this informally, and there might be an opportunity to just institutionalize this so that as time goes on, these practices become a part of the culture and are sustainable. But what's really important is that as you start this, you don't want other consequences to result from it. And so you want to be really proactive in making sure that people who are booked and released know about their court dates and can show up for them so that you don't then have a cascading effect of failures to appear. And we'll run through some of the strategies as we go on about how you might do that. We also suggest looking into facilitating driver's license reinstatement. We know Whatcom County has already attempted this in the past and has come across some challenges. We really encourage you to revisit what those challenges were and seeing if there are opportunities to facilitate this reinstatement and overcome those challenges. The full report offers a number of different opportunities, and I won't go into all of them now, but they involve finding alternatives to payment and then making consistent criteria across the 3 different courts so that people are able to make requests for payment relief and they're accepted or rejected in a similar manner. We were really encouraged as we began looking at what Whatcom was doing and Bellingham was doing around coordinating care for people with behavioral health needs. We did identify a couple areas that you should all consider as you continue moving forward with the GRACE program. And I went over this in much more detail earlier today, so I'm going to really try to make this brief. Defining high utilizers as people who come into contact with law enforcement and the jail in particular are going to be really important to ensure that the GRACE program targets a population that is using the jail. So while you want to also target people who have high usage of other systems like the health system, making sure that you really look at that portion of the pie is going to be important. Similarly, you'll want to develop off-ramps and make sure that people, once they are identified as being a GRACE program participant, know how they no longer have to be a GRACE program participant. So that's important for the individual, but also for GRACE as a program to understand when someone meets the criteria of becoming a high utilizer and when they no longer need those services. It will also allow you to plan plan so that they are successful once they are no longer a part of GRACE. Connecting them to legal services is very important both for criminal and civil, as someone pointed out in the previous meeting. Reasons, oftentimes legal challenges prevent or add an added complication to someone's life that exacerbate behavioral health needs, and so making sure legal services are available are important. We really encourage the incorporation of harm reduction strategies. I stepped in a little late to the prior presentation, but really making sure that people who both are ready to stop using drugs and those who are not ready to stop using drugs get the full benefit of the GRACE program. So really making sure that things like medicated assisted treatment are available to GRACE participants, making sure naloxone is available to people, and access to clean syringes can really minimize the negative consequences of drug use. An important part is making sure participation is non-compulsory. So people who do not choose to continue participation in the GRACE program don't see immediate legal consequences is important. Emphasizing transparency, this has already been started by the GRACE leadership team, but really getting people with direct impact is important to make sure that they understand what GRACE is and are therefore excited about it is extremely important. And then lastly, while GRACE focuses on high utilizers, there may be people who could be diverted that don't meet that standard. So we encourage Bellingham to consider other diversion opportunities, like perhaps a lead model.
And Vaden, I'm just going to interrupt. So for those at home that don't know what GRACE is, ground level entry coordinated response? Did I get it right?
Pretty close.
Okay.
It's a ground level response and coordinated engagement. And LEAD, the program that you're referring to, is the Seattle program, Law Enforcement Assisted Diversion.
Yeah, and the GRACE program is something that has come out of the Incarceration Prevention Task Force, and it's a joint commitment between municipalities and Whatcom County. So we're in the processes of implementation, I think, or development, moving towards implementation. Thank you. Go ahead.
As Steve pointed out earlier, the most frequent criminal traffic charge that resulted in an admission into the jail was DUI. We encourage Bellingham and perhaps Whatcom to consider establishing a sobering center where law enforcement could bring people who have been stopped on a DUI charge but have not had a previous conviction within the last 10 years. This would allow the community to respond to this rather than the jail to respond to this. And it could offer opportunities to connect people to longer-term care. And what's really important is that it's located in a convenient location for law enforcement, so it actually gets utilized. And then that would also potentially allow people to access the sobering center on their own. It could be a walk-in center. We encourage equipping law enforcement with de-escalation tools. We have to say that it appeared that Bellingham Police was already doing quite a bit in this area, and so we applaud Bellingham for that. They did mention CPIT, which is, where is it? crisis prevention and intervention teams, and they said that it was a great tool, but they only had access to it on certain days of the week, and they were really hoping that they would have more access to it. So we really encourage equipping or increasing the availability of CPIT to the Bellingham Police Department. Lastly, as Steve mentioned, probation and parole violations are a leading charge that results in an admission to the jail, and as we noted, that 56% had no accompanying new charge. So that leads us to believe that it's likely technical violations are causing those admissions. Technical violations are violations of the conditions of your community supervision and do not amount to a new crime. So there, and 80% of them were for local probation violations. So it appears that there's some opportunity for reform there. We really encourage Bellingham to think about emphasizing the reconnection of people to their officer rather than just resorting to a detention into the jail. And there are some strategies in the report, or one example in the report of how Santa Cruz has accomplished that.
We have a few of these slides that we call impact analysis, and the idea here is to show that the recommendations that our team is talking about have real and potentially measurable effects on how many people are admitted to the jail and what the jail population looks like on any given day. This last section we've been focused on admissions, the people with lower level charges or probation violations who come into jail. We're not thinking so much yet about the daily population. And what I did here was to show a few subpopulations with alternative outcomes based on the recommendations that Vaden just stated. And we're not really in the business of projecting what your jail is going to look like, so we're saying this is more like a what-if analysis. What if some of these recommendations had been in place in 2016? We know what the population looked like then, and we know what kind of impact these recommendations could have had. So the first one is to bring people who are arrested for the DUIs, but only those with no warrants and at most one other criminal traffic charge to a sobering center. We found that there were 709 admissions for people who met this description. And if through the recommendations you're able to cut that number by 25%, you would reduce 170 admissions by 177 people. If you were able to reduce it by 50%, you would reduce admissions by 355 over the course of the year, and 75% would be a 532 reduction in admissions. So you can see that they have they can take big slices of the number of admissions each year. The second one is about supervision violations. This is a specific set that had no new charges and that weren't eventually sentenced or resentenced based on their old charges. And there were 48 admissions like that, so you can see the numbers that by which admissions would be reduced for that group. And the last one is for the book and release of people with only misdemeanor or criminal traffic, not DUIs, and no warrants. There are 252 admissions that met this description in 2016. So depending how successful you are in addressing those admissions, a 25% success rate would reduce the population, would reduce the number of admissions by 63, 50% reduction would reduce them by 126, and a 75% reduction would reduce admissions by 189 people. And you can see the subtotals across the bottom. So these things, they're small numbers that start to add up, especially as we go through all the recommendations.
So as Steve and Vaden have both pointed out, warrants are likely driving misdemeanor and criminal traffic admissions to the jail significantly. You can see that overall, over 50% of those admitted into the jail had a warrant, and it's considerably more for misdemeanor and criminal traffic, those lower level offenses. And our criminal traffic numbers up there exclude DUIs. But 90% of those with driving with a license suspended in the third had a warrant attached to their case. And it is also likely contributing to multiple admissions within 1 year. For everybody admitted once, or for more than once in the jail, 73% of them had a warrant attached to their case. And so these put pressure on the number of people admitted into the jail, but warrants also likely take longer to resolve because sometimes they have to be addressed separately from new charges, or there's a different process as well.
And Christy, I think as you're doing this, just again for people in the audience and at home, is that as we look more at what Bellingham can do, we don't deal with the felonies necessarily. We're gross misdemeanors and misdemeanors.
Right. So
And
as
criminal traffic.
Yeah, so as Vaden mentioned, there are different strategies you can take to give someone a second chance, or there's a book and release warrant, right? The sheriff is doing for certain failures to appear, certain warrants. The sheriff is working with judges to issue a warrant that only brings the person in, books them, and then they're able to be released. So we recommend that a deeper dive is kind of needed to analyze what's facilitating these warrants. So you'll want to look at a few things. You want to look at the number of warrants to see maybe where you can get the biggest bang for your buck or where there's the biggest need. You want to look at the nature of the warrants to see what discretion Bellingham has to impact those calculations. And then you'll want to look at how old the warrants are, because some places what they've done is they said, okay, these warrants that are 15 years old for super low level offenses, it's too much to process, we're going to waive them. Other places have set up makeshift courts in the community to either quash the warrants completely or reschedule a court date. We heard from Nick Lewis from Lummi that they have amazing strategies that have been really successful for them, so they would be a really good partner. And then we also suggest that you could increase opportunities, to resolve those in the community.
And I think, and Darlene, you might correct me, but we did have a presentation on this, and for those that fail to appear for a court date, they can simply call the municipal court and ask for another court date. There's no cost. So if somebody misses that, which has been the case for a while, as well as we've been calling people before their court date pretty regularly.
Yeah,
so.
reminders are great. I mean, we have them for haircuts, for doctor's appointments. Court dates are pretty important too, so.
So this is another impact analysis. This is a pretty simple one. This time we're looking at the average daily population. So what we found is, looking at this description here, if you were to reduce bookings for gross misdemeanor, and non-DUI criminal traffic warrants, people who fit that description make up 31 of the average daily population. So by implementing the recommendations that Chrissy just talked about, you could reduce the population by 8. If you're 25, if you're successful 25% of the time in reducing them, by 15 or by 23, and those are all rounded numbers. So next we're going to talk about pretrial detention. We talked about it a little bit earlier. Some people are in the jail for being sentenced. Some people are in on holds, and this particular population, this particular segment of the population are people who are on holds from other jurisdictions, and that can include the federal government, the Department of Corrections, or who have fugitive warrants from other counties or other states or municipalities outside of Whatcom County. But the pretrial people are there who are in jail with pending cases only in Whatcom County, either municipalities or the county courts. So of that 192, what's keeping them in or what can get them out is bail. So this gives you an example of how bail is being used in the county. There were 5,279 admissions into the jail, not counting holds. Earlier I said it was around 6,000. This is taking the holds out. Of those 5,279, 444 people were released on personal recognizance before bail was ever set. 3,549 had bail assessed, And we learned earlier today that some of those people had bail assessed automatically, particularly on misdemeanor charges. Is that right? Mm-hmm. And the remainder are people who did not have bail assessed and were not released on personal recognizance, and most of them are people who were arriving at jail being sentenced. So they arrived to serve sentences. So if we just looked at the bail assessed part, you see the three different outcomes. 19% of the people were eventually released on their own recognizance after the bail had been set. 44% were released on bail, and 37% stayed in jail until the end of their cases, until their cases were disposed, or until they were sentenced. And these are the people who were unable to secure their freedom by posting bond. This is a little bit of a complicated chart. There's a lot going on here, but these are the different levels of bail that had been set only for the people who actually had bail set. If you look at the two leftmost bars, actually, if you look, first a quick explanation. The red color represents the people who were not released, who stayed in jail till the disposition of their cases at each level. The gray is for people who were released on their own recognizance, and the darkest color is for people who paid bond to secure the release. So you see in the lowest two bars of $1,000 or less bail that between
Steve, you got to bring that microphone a little closer to you. You're
Sorry.
a little difficult to hear. Thank you.
For the lowest two bars, and about 20% of the people with bond or with bail of $1,000 or less were not able to secure the release on bail. And if you go to the right of this table, excluding the last bar, so the second and third to the right are between $10,000 bail and $100,000 bail. And you see that about 40% of the people with these high bails, which presumably were meant to hold people in, were actually released. They were actually successful at posting bail. So people with high bail are getting out, and people with low bail are staying in.
So the big takeaway from Steve's last slide is that when judges or judicial officers are setting bail, they may have certain expectations when they're setting that bail that don't actually come to fruition. So they may set bail very low thinking this individual will be able to get out of jail, or they may set bail very high thinking this person will continue to be detained. And that's, as the data shows, not necessarily the case. And so we know that here locally, but we also know from national research that bail is increasingly being shown to not be effective. So jurisdictions across the country are moving towards becoming more risk-based instead of cash-based. And what this means is they're using tools to assess how likely is a person to show up for court and to commit new criminal activity in the pretrial period. So these tools are not meant to replace judicial decision-making. They are a tool to help improve judicial decision-making. And adopting a tool is a fairly in-depth process. There's a lot of excitement, I think, about it within the task force, and something that they're likely to pursue. But in the meantime, there are other more interim steps that can be taken to start moving away from cash bail. So the first example is ensuring that counsel is present at all bail decisions. We know that that's mostly the case here in Bellingham, other than when folks are arrested over the weekend and detained. There is a phone call that takes place between the county prosecutor and the judicial officer. Counsel is not present for that decision, although bail is set. So one recommendation would be to ensure that counsel is part of that conversation. And jurisdictions that have not had counsel at bail decisions and then added counsel saw a significant impact on their jail population, because people are more likely to be released on their own recognizance, which we should have said for those listening means just a promise to appear in court, and to be released more quickly. And as we said before, even just 2 to 3 days can have serious impact on a person's life and on public safety as well. And this is not relevant to Bellingham, but we encourage you to talk to your partners in some of the other municipalities to make sure that counsel is present at first appearances and arraignments. This is particularly important when individuals have the opportunity to enter a plea. You should always have the advice of counsel when doing so. Second is to develop a policy for early and meaningful bail review. What we've heard in conversations with stakeholders is that sometimes people can be detained without the opportunity to have their bail reviewed, so it may be set even very low, and they're not able to make that bail. So having a kind of a second look can be very helpful, and in some cases, pretrial services does this. They present a list of folks who are lower risk, who are most likely being detained solely because they have a low bond amount set, but they're too indigent to afford that bail. And so then the judge, in taking a second look, may be willing to release that person on recognizance. Next, it sounds like you're already doing some of this, implementing a court date reminder system. Like Christy said, we all get, sometimes texts, emails, phone calls from our dentists, so the courts should be doing that as well. And in many cases, folks who are lower risk, this is really all they need. They don't need any kind of intensive supervision. In fact, they're more likely to fail on intensive supervision. So just providing that reminder to show up to court is really all you need. And again, as I mentioned earlier, pretrial risk assessment tools are really an answer to cash bail and a more evidence-based and accurate answer. But they come with several other steps. So as you see here, you should train all of your staff that are using the tool, including attorneys, pretrial officers, judges, first and foremost. You should also establish quality assurance processes to make sure that people are using the tool as intended. That's not always the case, so you want to really, if you're going to make the effort and the investment in a tool, get it to its fullest extent and make sure that it's being used and that it's not being used inappropriately. Should also consider a decision-making framework. This is a little wonky, but I won't go too much into it, but it's basically a grid that judges can use when they know someone's risk level. They can then determine the level of supervision that they need to respond to that risk level. And finally, a validation study, which is done with quantitative researchers. They look at the predictions that the tool has made and whether those predictions were actually correct. And then they also make sure that biases aren't being inadvertently introduced by the tool. So it's really just making sure that the tool is doing what you think it's doing.
And you mentioned a study today, Liz, that was looking at the financial versus the risk assessment.
Yes.
So the bail versus having a risk assessment tool and then deciding is somebody low risk, high risk. And that I think you said there was a 30% decrease in some areas with this pretrial costs, and you were explaining that the bail system for the financial could allow somebody that's really high risk to be released, which could impact the community a lot more,
right,
and then leave somebody in jail that is low risk that just couldn't afford to do it.
Exactly.
Did I explain that?
Okay. That was really great. So that's from a study out of Texas. They compared two different counties. One was using a tool, one was not. The one that was using a tool had 30% lower pretrial costs. First, because not as many people were being detained, low risk people were being released, and pretty quickly. And then higher risk people were not being inappropriately released. So what they found in the county that was using cash bail, and as Steve mentioned earlier, many folks who are higher risk may be released because they post that bail. They were going on to commit new offenses, and so then you have costs around victim costs and then processing that new case, and they were also failing to appear because they were, again, inappropriately released, and so then you have to process warrants, and so they really saw a reduction in their costs when they were using that tool because they were releasing the right people.
Thank you.
Yep.
I have a question.
Pinky, yes.
I'm aware of what Bellingham is doing, but not so much what the county is doing, and I know that we have a pretty robust reminder system, and I'm curious what the county, can you compare the two, the city and the county, on where we're at on these things?
Yes. So I think there are varying levels of implementation happening across the different courts. It sounds like in district court there are some reminders that are done through district court probation. So if people are under pretrial supervision or probation supervision, they are receiving reminders. And I would just say our recommendation would be to have reminders universally. So it shouldn't be a requirement that someone is on supervision to get a reminder. It should be universal. If you post bail or you PR, whatever the cause of your release, you should still be getting a reminder. And none of the courts are using a risk assessment yet. I know Bellingham Municipal does use a tool in terms of electronic monitoring. But I think this is one where if you were to adopt a tool, if all of the different courts kind of pooled their resources and did this together, it would be most cost effective. But then you would also make sure that people, no matter what court they're in, have the same opportunities for release.
Terry?
Yeah, I got a question. It kind of goes back to one of the early slides. I was kind of waiting until the end, but I see questions that are going to be
yeah, and we've gone way
so I figured
over time.
I should probably jump in.
So, yeah.
One of the early slides showed about the low-risk people held for more than 8 days had a greater risk of reoffending or recidivism. The implications are that it's being held longer has the effect on recidivism. When you looked at it, what elements did you look at that showed that as opposed to those that were held had a greater risk to reoffend to begin with because of risk factors in their lives? Because I agree, risk assessment's a good idea when you're looking at those, but because some people go to one and others look at, oh, well, they were right. That's why they were held.
Yeah.
So what did you look at with that would show it's one way as opposed to the other?
Yeah, so it's a really good question, and I wish Vera could take credit for that research, but we didn't actually conduct the research. Several other, a foundation and also some universities have done this research. But so it's interesting because it seems really counterintuitive that detaining people, when people are detained, that they're more likely to commit offenses and to fail to appear for court. It seems like it should be the other way. But what the research did is it compared apples to apples. So they compared identical defendants, so similar back case histories, criminal history, similar current charges, similar demographics. So they were able to control for all of those differences. The only thing, the thing that they looked at specifically was whether someone was released pretrial or not. So that was really the only difference. And so that suggests that it's actually the incarceration itself that is making that person more likely both to fail to appear and to commit a new offense, both in the pretrial phase and up to 2 years later. And there's been a very recent study by the University of Pennsylvania that has actually been able to show that it is a causal relationship, not just correlational.
Yeah, impacts on life, jail, education, family, all the things that you're
Exactly.
removed from that make it so much more difficult to go back into society.
Absolutely. Yep. And then finally, our last recommendation in this area, pretrial detention, is to establish a regional pretrial services program. We know that district court probation is already doing pretrial supervision. They've shown a real interest in evidence-based practices, and so being able to extend their services across all of the courts would really increase the number of people that can be released pre-trial.
This is, excuse me, this is one more impact analysis. The important takeaway from this is that because the pretrial population is so big, there are 192 people in the jail on any given day who are there pre-trial, that even moderate success can make great gains in reducing the population. For here, I'm just going to focus on the top line because that's for the misdemeanors, gross misdemeanors, and criminal traffic. So the average daily population of pretrial people with those charges was 43, and then you can see the various reductions in the average daily population if you are able to carve out 25, 50, or 75% of them. The bottom line shows overall what you could do if you are equally successful in dealing with drug felonies and other felonies. We're going to look at case processing now. This is what happens in the courts. For this, we received data from the State Office of Court Administration, and it wasn't the easiest data to work with, and we couldn't draw a whole lot of conclusions, but mostly we were able to determine how long cases were lasting from beginning to disposition. And what we did was we compared how many of each length of case, whether they were within 60 days, 90 days, to standards that were established by a national board or by Washington State. So what you see here is the second column, the NCSC, is the national standard that 75% of misdemeanor cases should be resolved within 60 days. 90% should be resolved within 90 days, and 98% within 180 days. The Washington standard is pretty close. They just add on that 100% should be resolved in 270 days. And what you see in the next two columns are what's happening in the Whatcom District Court for misdemeanors and in Bellingham Municipal Court. So in Bellingham Municipal Court, 42% of cases are being resolved within 60 days. 50% are resolved within 90 days, below the 90% aspirational standards. And then 73 are being resolved within 180 days, and 86% within 270 days. These are cases that are only in Bellingham Municipal Court. We found that people who have cases pending before this court, on average, spend 5.5 days in jail. Some of those people are actually serving some sentence time, but the average pretrial number of days in jail is 3.5. And there were 893 bookings for people who only had cases in the Bellingham court.
Okay, and Steve, I will say that in committee today, somebody had asked the aspirational question, and those are very aspirational numbers. Those are not being attained across Washington State. However, one of the suggestions was for us to set our own aspirations. Mr. Bordeman?
Yeah. On on that number, are the FTAs removed when considering the number of days for resolution of a case?
No, you actually remind me of an important point, is that we don't know for all these cases whether or not somebody is in jail or if they're out on bail or they're on recognizance. We weren't able to tie the court data to the jail data to determine that. But no, the FTAs weren't taken out, but we did find some cases were lasting a very long time, possibly because people had stopped appearing for court appearances. And what we did was we capped the outliers. We cut off the outliers so they wouldn't distort our analysis too much.
Councilmember Vargas?
Steve, I have two quick questions. I found these numbers pretty staggering. What were the analysis on why the percentage was so great? Is it lack of staff? Is it the way we're doing things? Why is that so dramatic, that 42% and 47% compared to the national average?
I'm going to pass that one over to Liz, who can probably answer it more clearly than I can.
You can. So, unfortunately, the data didn't tell us why. And that's, actually, you can advance, yeah, sorry. And so that's what we would, part of our what we would recommend, that you look into what's causing those delays, because really what we had is just the overall time from the beginning of the case to the end. And so we encourage you, and we mentioned earlier in the task force meeting, this is a real area of interest currently. I think many courts across the country are realizing that their case backlogs are part of the problem, so they're looking at ways to expedite their case processing. And so one of our recommendations is to develop a case flow management plan that starts with setting, as you said, council member, setting your own goals. You could choose for your court to adopt the standards of the National Center for State Courts or for Washington State, or if that felt too aggressive, you could start a bit lower and then increase as you go along. And so some of the other steps that should be built into this plan is early court involvement and continuing control. All of the stakeholders who are part of the justice system should be involved, but it's really up to the judges and the judicial officers to keep everyone on task and make sure that the case isn't dragging. So this includes treating cases proportionately. So that could be having different tracks. So you have your least complex, your moderate, and your most complex cases, and tailoring your approach to each of those cases and allocating your resources appropriately to make sure that each of those tracks moves as it should. Establishing meaningful court events. So as we said, in the research, we couldn't tell what the cause of the delay was, but one thing that we did hear consistently in talking to task force members is the use of continuances really drags things out, and that's universal across most of the courts where we at VERA have worked. So it may be establishing a policy.
Please explain what continuances are.
Sure. So continuances is a request by the attorneys to set the case out. So you could all show up for court and someone may not be prepared, or let's say the defendant failed to appear. You would continue the case to a future date. And so the judges should be tracking why they're why they're granting continuances, who's requesting them, how often, and the time between court events. So even some jurisdictions have found shaving off some of the days that are allowed for continuance can have a real impact. And making sure, too, that when someone is granted a continuance, that what they say they're going to do during that time is actually being accomplished. And putting these policies into writing can be very effective.
The second part of my question was, we have a comparative of the Bellingham Municipal Court on average days is 5.5. That's on page 179. What's the district?
Oh, I don't, we have the calculation.
I don't think we have that one.
No, I think we actually just did this analysis. I'm sorry. We just did this analysis particularly for this council. We didn't.
Okay, so we don't
have
know
all those
what
numbers handy.
the average days in jail accounted for are through the county.
No,
okay.
sorry.
Thank you.
But if you look at the previous slide, you will see that the district court and Bellingham Municipal are resolving their cases at a similar rate. So finally, we would recommend, again, tracking your performance measures. So you can have overall measures, how long is it taking from the beginning to the end of the case, but then you can also have interim measures. So how many court appearances per case, how long between those appearances, how long does it take to get discovery, things like that. And again, this question of in custody versus out of custody, which we were not able to determine. And this may mean working with the jail to be able to cross-reference your data between jail and courts. And so we're going to actually skip our last recommendation, but it was to reconvene the Law and Justice Council in Whatcom County. What we've seen consistently across the country is that having a body that is working collaboratively and represents all of the justice system agencies as well as the community is really effective in making sure that reform is implemented but also sustained over time.
Thank you. Council members? Dan.
I just have one question. This goes back to your book and release from the police station and then PRing the person back to the community, so release on personal recognizance for theft third and criminal trespass second. Is it the shock of being at a police station that, I mean, really, because they're not in jail and it's not a field citation, so it's in between thing where they're among police officers or at a kind of a official facility. Is that the theory, and is there evidence from other communities that that this works?
Yeah, so we know of two communities in particular. It happens across the country, but two examples that we draw on frequently are Milwaukee and New York City. I know those are much bigger communities, but because they have so many people processing through their courts, they really needed to implement this policy by necessity. So what happens is the officer encounters the person in the field, but they may not be able to do certain things that the jail normally does. So fingerprinting, photographing, they can do that at the station. And so they take the person to the station, they do those activities, and then they give them a ticket, and the person goes on their way. And what they have found is that making sure that the first appearance is relatively soon after that event is important. When it's several weeks away, that you're more likely to see failures to appear. But also, again, providing reminders to make sure that they show up, because then you don't want to inadvertently create more failures to appear.
Okay, thank you.
Is it also a reduction in cost? I know at some point we were getting charged every time we booked somebody,
Right.
regardless if
Yep.
they went out.
It's-
So if you did it
it's-
at your own municipal.
Yep, you avoid using the jail, and you don't have that cost of booking someone into the jail. But then you also, again, going back to the impact on the individual, you're preventing some of the impact on that person.
Pinky, did you have a question?
Quick question. I'm not sure who the presentation was to this morning. Did it go to county,
It was to the full task force.
to the full task force? Is this presentation going to the county council?
The county council, if I understand correctly, will have a presentation from the task force. If you would like to listen to what happened today, it was recorded. You can download the slides, and you can go to the Whatcom County website to find that.
Yeah, and the last time we were in town back in July, we didn't have our recommendations yet, but we did a similar presentation of our initial data findings for the county council.
All right. Well, with that, thank you so much for taking the time. We know that you've come all the way up and stayed extra to give this. Thank you to the Whatcom County Council, who have allowed, because they've been the ones paying for you all to work on this. So thank you so much, County Council. And I really want to say thank you, Deb Lev, our judge. Judge Deb Lev is not here today, but she's not only been putting in a lot of effort, as well as Chief Cook, with the new Justice Committee that we've done, but I think it shows that we've been working really well with our legal team. Peter Rafato's here as well, to really get these things that you've suggested. And then there's some things that we can look at as a Justice Committee and as a group as well. So I appreciate all of your time. Thank you, Council, for allowing them to do their presentation. And with that, end of committee.
Okay, thank you very much. Thank you very much, your entire team. Liz,